So it is 2024 Pride, and we have been discussing the court cases and the legislation that has been passed to give our LGBTQIA plus siblings basic rights. Like, I don't know, getting freaky in their own homes without fear of being arrested, because that was legitimately a thing. Yeah. How about this one? Legally getting married, because that's a thing too. They weren't able to do that. And that's what we are discussing right now. We are talking about Obergefell versus Hodges, which was decided in 2015 and legalized gay marriage. Yesterday, we talked about the court cases, the 6 court cases that was condensed down into 4, which was condensed down into 1. What happened was the 4 court cases went to the Court of Appeals, the 4th, 7th, 9th, and 10th circuits. They all said that state-level bans on same-sex marriage were unconstitutional. But the 6th Circuit ruled that it was bound by Baker versus Nelson. You remember that court case. It was against Minnesota's same-sex ban, and the Supreme Court said that it was constitutional. And the 6th Circuit said it was bound by that decision. Well, this created a split decision between circuits, and it led to a Supreme Court review. All of the cases were then combined into one case, Obergefell versus Hodges, and it was then reviewed by the Supreme Court. Let's discuss the decision. On June 26, 2015, on the 2nd anniversary of the United States versus Windsor, that's the one that struck down Section 3 of the Defense of Marriage Act, which defined federal recognition to same-sex marriages as being unconstitutional, and on the 12th anniversary of Lawrence versus Texas, which struck down same-sex loving in 13 states, the Supreme Court brought down the verdict of Obergefell versus Hodges. And the Supreme Court held in a 5-4 decision that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. It required all 50 states, the District of Columbia, and the territories to perform and recognize the marriages of same-sex couples on the same terms and conditions as the marriages of opposite-sex couples, with all of the accompanying rights and responsibilities. And a joyous day was had by all, except for maybe Christian conservatives. Now, Justice Anthony Kennedy, he authored the opinion, and he was joined by Ruth Bader Ginsburg. And I want you to guess who dissented. Just guess. Did somebody say Scalia and Alito and Thomas? Because you'd be right. They indeed dissented. Yeah. Doesn't matter. Majority, though, said that bans on same-sex marriage were a violation of the 14th Amendment, right? And Kennedy cited Griswold versus Connecticut, which gave us the right to contraception. But in citing them, the court affirmed that the fundamental rights found in the 14th Amendment Due Process Clause extended to certain personal choices central to individual dignity and autonomy, including intimate choices that define personal identity and beliefs. He then cited United States versus Windsor and listed why the right to marry applied to same-sex couples. First, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry is fundamental because it supports a two-person union unlike any other in its importance to the committed individuals, a principle applying equally to same-sex couples. Third, the right to marry in the United States has never been conditioned on procreation. Fourth, and lastly, marriage is a keystone of our social order, and there is no difference between same and opposite sex couples with respect to this principle. Consequently, preventing same-sex couples from marrying puts them at odds with society, denies them countless benefits of marriage, and introduces instability into their relationships for no justifiable reason. Oh, and the argument that the right to same-sex marriage should follow the democratic process, voting. The courts had this to say, or Kennedy had this to say. An individual can invoke a right to constitutional protection when he or she is harmed, even if the broader public disagrees and even if the legislature refuses to act, for fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. Short version, you can't vote on basic human rights. Now, as for the dissenters, Scalia argued that the decision robbed people of the right to govern themselves. He felt that it should be voted on. Thomas did not believe in substantive rights, or rather, he didn't believe that they were covered under the Constitution. And Alito was the idiot who did not believe that same-sex marriage was deeply rooted in the nation's history and tradition. With the exception of Thomas, it didn't matter what they said at all. Now, it matters what Thomas says, because what he says will be repeated when Roe versus Wade is overturned in 2020. Regardless, same-sex couples have had the right to marry for as long as my oldest grandson has been alive. Same-sex couples have had the right to marry for as long as I have been in Minnesota. 9 years. That's it. A basic human right, the right to marry. And they've only had it for 9 years.